Our next speakers will be talking about anti-SLAPP legislation, and this, as you probably know, is legislation that governments are putting in most jurisdictions in North America, which is to protect whistleblowers, people, journalists, people who speak in the public interest from lawsuits that are just designed to shut them up when they're speaking the truth to power. So to explain that concept more fully and to discuss some of the cases in Canada that have considered that, we have Nicola Brankley and Linda Phillips-Smith, starting with Nicola.
Thanks, Frank. And I'd like to start off by giving our thanks to our colleague Noah Eklov, who is really the main author on our paper and a tremendous help in getting us to where we're at today. And thank you all for joining us and for staying with us through to this last presentation. So a strategic lawsuit against public participation, or a SLAPP action. It's a legal proceeding that's intending to silence a group or an individual who speaks out on matters of public importance. Its purpose is really to silence critics who have less financial means by forcing them to spend time and money to defend baseless lawsuits. We often see these through defamation claims, but they can also be claims in negligence, negligent misrepresentation, or intentional interference with contractual relations. In response to seeing a number of these SLAPP actions being brought before the courts, in 2015, the legislation was changed to introduce what we refer to as anti-SLAPP legislation. It's found in Section 137.1 of the Courts of Justice Act. And its aim is to balance the protection of freedom of expression in matters of public interest with the protection of reputation and economic interests. The way that expression is defined in the anti-SLAPP legislation is very broad. It means any communication, whether it's verbal or nonverbal, whether it's made publicly or privately, and whether or not it's directed to a person or to an entity. The legislation accomplishes its goal of balancing these interests by allowing judges on motion to dismiss certain actions without the need or time of a costly trial. Of course, not every action is going to be able to be dismissed on an anti-SLAPP motion, and so the legislation sets out elements for what's needed in order to survive an anti-SLAPP motion. We're going to look in some detail as to how the Supreme Court of Canada has said that this test should be applied in practice, but before we get to that, I want to highlight a few other provisions of interest in the anti-SLAPP legislation for you to be aware of. Beginning first with subsection 5, it lets us know that once a motion has been made, once an anti-SLAPP motion has been made, no further steps in the proceeding can be taken by any party until that motion and any appeal from that motion have been decided. So really, bringing an anti-SLAPP motion has the effect of stopping everything in the action in its tracks. So that's something to really keep in mind when you're deciding your timing of when you might want to bring an anti-SLAPP motion. Subsection 6 actually goes further and says that there can be no amendments made to a pleading to try and bolster a claim and make it look more legitimate, or to try and continue the claim after a dismissal. So this ties in with subsection 5, and read together, it would mean that a plaintiff cannot amend their claim once an anti-SLAPP motion has been brought. And as we've seen in a case that was released just last month, this actually goes so far as to mean that a plaintiff could not even discontinue their claim at that point either. So a plaintiff cannot try and avoid losing on a motion and being faced with cost consequences simply by stepping away or dropping their case. They have to face the music or face judgment, as it were. The legislation also sets out some costs expectations in subsections 7 and 8. If a defendant is successful on their anti-SLAPP motion, then they are presumptively entitled to their costs on a full indemnity basis, both for the motion and for the action. This is actually quite an important consideration because as we've seen with some of the cases coming out in anti-SLAPP motions, the costs that are incurred in bringing these motions can actually be quite substantial. If a defendant is unsuccessful on their anti-SLAPP motion, the presumption is that the plaintiff is not entitled to any of their costs, despite them being the successful party. So what we're really seeing with these provisions is a focus on the legislation trying to protect defendants who may well be more vulnerable or who have fewer resources. The trick, however, is that it's always left to the discretion of the judge to decide if these provisions should be enforced. And what the courts have shown us in some of their more recent decisions is that they are very willing to use that discretion and stick with awarding partial indemnity costs, depending upon the facts before them. The last provision I want to highlight is subsection 9, and it's one that I find particularly interesting. If a defendant is successful on their anti-SLAPP motion, they can actually be awarded damages themselves. To do so requires the judge to find that the plaintiff brought the action in bad faith or for an improper purpose. Now, in a true SLAPP action, that may not actually be that hard to prove, but it's certainly not going to be in every case. What this section does is it really acts as a punishment for an improper plaintiff, and ideally it acts as a deterrent as well to stop these types of actions from being brought in the first place. The damages that you might be awarded under this subsection are likely nominal, so maybe $2,000 or $3,000, but it is worth considering asking for this relief when you're bringing a motion if you think that bad faith or improper purpose could be borne out. So looking at the actual motion under the anti-SLAPP legislation, the Supreme Court has clarified the test in 2 recent cases: Points, which is a breach of contract case, and Bent, which is a defamation action. It's a 3-step test. Step 1 is our threshold burden. Step 2 is our merits-based hurdle, and Step 3 is the public interest hurdle. The courts have really emphasized that there are 2 overarching goals of the anti-SLAPP legislation. First is to screen out lawsuits that limit expressions on matters of public interest, and second is to ensure that a plaintiff with a legitimate claim is not unduly denied the opportunity to pursue it. And these goals are to be kept in mind by courts when they actually apply the framework. So step 1, our threshold burden. At this first step, the moving party, which will be the defendant, has to establish that the proceeding arises from an expression made by the defendant, which relates to a matter of public interest. Now, all of these terms are quite broadly defined. For example, arises from only requires that the expression be causally related to the proceedings. As we saw in the definition of expression earlier, it too is quite broad. Any form of verbal, nonverbal, private, or public communication can be counted as an expression. The courts have told us that there is no single test to determine public interest at step 1. What you need to do is assess the expression as a whole, asking whether some segment of the community would have a genuine interest in receiving information on the subject. At step 1, it's not a qualitative assessment of the expression, but rather it's an objective determination of whether, on balanced probabilities, the content of the expression is a matter of public interest. At step 2, the merits-based hurdle, the burden shifts to the plaintiff, and the plaintiff has to show both that there are grounds to believe that the plaintiff's claim has substantial merit and that the defendant has no valid defenses. If the plaintiff does not meet its burden at step 2, then the underlying claim should be dismissed. So what's meant by grounds to believe? Well, the courts have told us that it's a higher standard than the plain and obvious or some chance of success that's required on a motion to strike, but it's a lower standard than is required on a motion for summary judgment. So really it's sandwiched in between those 2 standards. And had I realized that our presentation was so close to lunch, I probably wouldn't have used a grilled cheese sandwich because I'm hungry and I now know what I need to go find to have lunch later. So grounds to believe, it's a subjective test that's based on the motion judge's determination. So the judge has to conclude from their assessment of the evidence that there's a basis in both fact and in law to support that the claim has substantial merit and that all of the defenses are invalid. So this means that there has to be no defenses that could succeed, and that might be a pretty high hurdle for a plaintiff to meet at this step 2. So that takes us to step 3. You've cleared the threshold hurdle, you've cleared the merits-based hurdle, and we get to the public interest hurdle. This is really the crux of the anti-SLAPP legislation. It's what provides the motion judge with the ability to dismiss claims that technically have merit on the basis that they're not in the public interest to allow to proceed. So at step 3, the judge has to determine whether there's more weight to the harm being suffered by the plaintiff or to the public interest in protecting this expression. It's a weighing exercise. It's not a balancing exercise. So that means that one of these considerations at the end of the day has to in fact outweigh the other. There are 2 parts to the public interest hurdle. There's a harm analysis and there's a weighing of the public interest. With respect to the harm analysis, the plaintiff has to prove the existence of harm. So this could be monetary, such as a loss of income or a loss of a contract, or it could be non-monetary, such as damage to your reputation. The plaintiff also has to show that the harm was suffered as a result of the defendant's expression. When it comes to weighing the public interest, we're talking about a different public interest than from step one. While step one is concerned with the objective and not qualitative assessment, here the quality and motivation of the expression are relevant for determining the level of protection that should be afforded. When we're weighing the public interest, the analysis is going to be guided by the core values of Section 2B of the Charter, which of course is our right to freedom of expression. And courts in the past have told us that some of these core values include the search for truth, participation in political decision-making, and diversity in forms of self-fulfillment and human flourishing. So the closer the expression is to one of these core values, then the greater the public interest is in protecting it. The form of the expression is also going to impact its weight. So for example, testimony before a court or tribunal is going to be entitled to a higher level of protection, because otherwise it undermines the integrity of the judicial system if there's a fear of legal retaliation from your testimony or the evidence that you gave. On the other hand, an unverified allegation that simply impugns a plaintiff's professional reputation will probably fall on the lower end of the spectrum and be entitled to less protection. So after all of these analyses, the court has to determine if the action should be struck. And when the courts are faced with anti-SLAPP motions, they're concerned with shutting the courtroom door on a plaintiff who has a claim that may have ultimately succeeded on the merits. So for the courts, the focus of an anti-SLAPP motion should really be on those cases where a plaintiff has a technically valid case, but who suffers insignificant harm. We sometimes joke when we're talking about our files about the smell test, but the Court of Appeal of Ontario has actually suggested that it might have a place in some of the considerations. So consider, does the case smell of a genuine controversy and therefore should be tried on its merits? Or does it have characteristics that reek of a plaintiff's improper motive or claims of phantom harms or bullying tactics? So we now have guidance from the Supreme Court of Canada on how anti-SLAPP legislation should be applied. What's next is really to see how that's being put into practice and if that test actually upholds the legislation's intention of protecting important expressions in a quick and less costly manner.
Thank you very much, Nicola. There is one question which will be answered by our next speaker regarding the Subway and CBC and Trent case. And Linda will be discussing that, and I promise you that your question will be answered in the context of her presentation. So, Linda, over to you.
Thank you. Just trying to get organized. Sorry. So they've. I want to thank all the speakers that have preceded me. They make it very easy because if I blow it, you know, we've got the balance of the presentations have been really good, so this has been a good presentation. I want to thank them all for it. What I'm doing is just going to take a bit of a look at answering the question, is anti-SLAPP working? And we have to really hope that it is, because it's being applied in multiple jurisdictions, including Ontario, in a lot of different legal venue or actions. They go everywhere from community groups to consumers, internet speech cases, corporate cases, environmental cases, nonprofits, obviously involve the press and the media, small businesses, sexual assault cases. There's a myriad of them, and and it's growing. So it's something that it's important that we understand, and it's important that it works. Now, what I'm going to look at is, you know, really answer, is it working, or is it working the way it should? And that's really the question that we can look at now, because we're still in the infancy in Ontario, and I don't want to presume that we have all of the answers yet. The first thing you have to remember is that everything has to be grounded in an expression. So historically, when this first came about, as the Subway case, Subway and Trent showed, the trial judge dismissed all of the action against Trent in negligence because it was not an expressive tort. That is, it's not defamation. So the idea is that because it has to be grounded in expression, meant that it should only be applied to defamation. Well, the Subway franchise case now has shown that that's not the case, that is not the situation. Just to recap, Subway franchise, because I know Alana spoke about it, was a case that CBC published a Trent study that looked at the composition of chicken sandwiches, and in particular the percentage chicken in the sandwich, and Trent concluded that Subway had misrepresented the percentage of chicken in their sandwiches. That got published on the CBC, and Subway sued CBC in defamation and sued in the same action Trent in both defamation and negligence. The Court of Appeal issued 2 decisions, one in which they allowed the Subway action against CBC and Trent to proceed in defamation because they found that there had been alleged defenses, or the defenses, were valid, and so the action could proceed. So they dismissed the motion, the anti-SLAPP motion. But then they issued a separate decision, and that's the one that we have here, because I'm not going to go through everything, but where they said, look, the fact that it's not a defamation claim doesn't mean that anti-SLAPP can't apply. It doesn't just apply to expressive torts like defamation. It's as long as there's a nexus between the legal action and the expression. So that meant that this is opened up to cases well beyond defamation. And in fact, the Point Supreme Court of Canada case that we'll talk about later stem from breach of contract. So the next thing that you have to remember is, and this is actually central and perhaps the most important point of the entire anti-SLAPP, is that it has to be a matter of public interest. If you don't trigger public interest, you get nowhere. So what is public interest? This is the absolute core. It's the crux. They even say so. So what did Points do when they tried to define public interest? The Supreme Court of Canada went to the case in Torstar, and Beverly McLaughlin said that public interest is not just what interests the public, but it's got to be something that citizens have substantial concern about because it affects their welfare. And this can involve a variety of matters: science to the arts, environment, religion, morality. There's not a limit in the subject matter. So it's a very wide scope. That's the definition of public interest. So applying that, what has happened? And I'm only going to look at 2 cases, but I can tell you that courts vary on how they apply it. And I want to draw your attention to 2 Facebook posts. Now, the first one is the Story decision. A young woman died in a motor vehicle accident because Story, a police officer, drove his car into her, and he was charged and convicted. Now, he then posted on Facebook negative comments about her bad driving, and other things associated with the trial, even some things about her family and so forth. Her family then sued Story for defamation. S brought an anti-SLAPP to try to defeat the family's claim, saying that, in fact, he was talking about how he was persecuted in the trial and there was reasons for it, and this was a matter of public interest. The courts denied Story's anti-SLAPP motion because they said that it was a personal communication. It was his view on the trial, and it wasn't of public interest. It might have been interesting to the public, but it wasn't a matter of public interest. And in doing so, they said that you have to look at what the communication was about, and that you can never have an exhaustive definition. The second Facebook post that I want to draw to your attention is Smith and Nagy. Now, they were involved in a long-term relationship that broke up. And after it broke up, Smith posted that her ex-lover, common-law husband, abused her. Now, they were both involved in producing games and such on the web, and this was killing his career because nobody was going to work for him. So he sued her in defamation. She then brought an anti-SLAPP motion. The court found that this was a matter of public interest. because it was important to the community who worked with S to need to know his reputation. Now, you have to query this because it did dramatically interest the community he worked in. You have unproven allegations of abuse that now have destroyed his career. That seems to me to be the very subject matter of what defamation is there to prevent, to address. If it's true, fine, go on with it. If it's not true, you have to pay some damages. But he was denied that opportunity. And so you have then the two Facebook posts, one that's public interest because it talks about the Me Too movement, and one that's not public interest because it talks about an accident victim involved in an accident and her family that is judged to have nothing to do with the relevancy of evidence at trial and so forth. So they both referred to Points. So what was Points about? And why was it unanimous? Well, Points was, in fact, an easy case for the Supreme Court of Canada to be unanimous upon. And to find this broad interpretation of public interest, because of the easy facts of it, everyone can agree, within measure, I suppose. Points was a nonprofit corporation developed by local residents to oppose a development of 170. 170 required Conservation Authority approval and City Council for that development, and it eventually obtained the Conservation Authority approval, which Points then contested via judicial review. During that judicial review process, the two parties reached a settlement agreement, and Points undertook that it would not contest that the Conservation Authority exceeded its jurisdiction or that anything it did was invalid. And that was part of the settlement agreement or the contract. 170 then took the matter back to City Council, who rejected it, and predictably they went to the OMB. At the OMB, the Points president testified that the development would cause environmental damage. Subsequently, the OMB, after hearing multiple witnesses and hearing evidence from all parties, dismissed 170's appeal on a variety of grounds. So while they accepted the Points president's testimony, they didn't stipulate that they dismissed it on that ground. They dismissed it on a wide variety of grounds related to mostly the planning process. 170 then, no doubt in a bit piqued at the denial of its application, commenced an action against Points for breach of contract, i.e. that they spoke against them. Now, the important thing here is that I want to draw to your attention is why, in this case, public interest was easy to find. Certainly, Gagnon's testimony was an expression that related to matters of public interest. We can all agree on that. I don't think there would be very many people who wouldn't agree that there's public interest in environmental impact and environmental damage of development. The second thing that was perhaps even more important to the court is that it's of fundamental importance that witnesses that appear before tribunals and courts can't be afraid of later legal retaliation. So on that interest alone, there's some serious public interest to Points. Now, I'm going to just sort of switch out of public interest for a minute, because then you remember that the test goes to looking at harm, because eventually there has to be a weighing of the public interest to the harm. After finding that there was substantial merit, they then went to, and defenses, they then went to look at, after they'd considered substantial merit and the defenses, they then went to look at harm. Now, when they looked at harm, they found that there was no harm to 170. In fact, there was no causation. So you can quickly see where they're going with the weighing. But the important point here, and I'll raise this a little bit later, is that on the entire 137.4 test, the court emphasized the importance of actually looking at real evidence. In other words, 170 had originally appeared basically on submitting their pleadings that they needed $6 million for damage, and the court said, no, you need to actually show us show us some damage. Not necessarily trial type proof of damage, but we need to understand it a lot better. So you need evidence to show substantial merit, you need evidence to show whether or not there's valid defenses, and you need evidence to show that, in fact, you have damage. Now, the important point to all of that is that you have, therefore, public interest, which has to be weighed against harm. You have and you have evidence that you need to establish 134 in 134 motions. So how does that then relate when you get into more complicated actions? Can you predict what's going to happen? How is this all going to be advanced? Well, the second case that was heard at the same time as point was Bent versus Platnick. And in that case, there was no unanimity, partly because the courts found very different decisions on evidence, and then they found very different decisions on public policy or public interest. In this case, Bent was a partner at Learners and the president of OTLA. Platnick was a doctor who was hired by insurance companies to help them sort out AB claims. During the case of Bent, while Bent was working on an arbitration, she received some Platnick's reports that she subsequently thought had been altered by Platnick. She then served and emailed a listserv of 670 OTLA members alleging that he altered reports and changed another doctor's decision. That email was subsequently leaked to a magazine which published it, and Platnick's career was destroyed, and he sued Bent for $6 million. Now, what did the email say? Because it's important that we actually get into the weeds a little bit about this one. At arbitration, you remember Bent was cross-examining a Dr. King, and she put to him that she had different drafts of his report, and he looked at it and he said, look, the final report that he submitted to Sibley was not the same as the one that she submitted, that significant sections had been deleted without his knowledge. It was about that time that she then looked at the Platnick executive summary and realized that Platnick had attached this IME that contained the deletions. Platnick was to appear shortly thereafter for cross-examination, and the insurance company prior to that cross-examination apparently offered an obscene amount of money, according to Bent, to settle the claim, and there was no further cross-examination. Now, the second, she sent in her email, she detailed that, and then she also detailed that this wasn't the only report which he had altered, and that she had, in fact, saw another report where she names Dr. Platnick and says that he changed the doctor's decision with respect to impairment ratings. Now, at the court below, the court allowed Bent's motion, saying that this was a matter of public interest and that the action had substantial merit, and that Bent had valid defenses. Sorry, he denied Platnick's motion, saying that Bent had valid defenses and qualified privilege of justification, qualified privilege, justification being the truth of the matter, and qualified privilege being that she sent the email under the expectation of confidence. He then went to the weighing exercise and said public interest in protecting Bent's freedom of expression outweighed the interest in permitting the defamation action. The Court of Appeal allowed the appeal on the merits and found that there was no defenses available to Bent. So on the evidence, they completely did a 180 and found complete opposite, and they dismissed Bent's motion and allowed the defamation action to proceed. There is an interesting little wrinkle here about late evidence, because Platnick got some evidence just prior to the end of trial, or prior to the time the trial judge issued his decision, that questioned Bent's available defenses, and I won't get into that too much. But now what happened is that you go to the Supreme Court of Canada, and there you have a 5-4 split. The majority said that the expression related to public interest, and so did the minority. They all agreed that that this was an email sent to a group of people advocating for the injured, and therefore there was a public interest. They also found that the defamation action had substantial merit based on all of the evidence tendered. But where they differed was with respect to the defenses. Now, some of this related to the fact that in the majority they allowed the fresh evidence, and in the majority they rejected the fresh evidence. But apart from that, one can see that what they did is they looked at the legal analysis on what the evidence was based on the law of defamation, and in the majority they found that there was no defenses, and in the dissent they said that no, there was a valid defense of qualified privilege. So the dissent on that basis alone would have said, the motion had to fail. Nonetheless, everybody went forward to look at the harm calculation. Again here, looking at the evidence, the majority said that there was extensive harm. In so doing, they had to weigh the difference between whether the harm was because of the original email that was sent to listserv or due to the republication. The majority found on the evidence that the republication to the magazine was foreseeable because, frankly, lawyers are active rumor mill and gossips, and she should have known that. I can't defend that. It's true. And that and that the subsequent evidence that the dissent didn't hear was that Bent was aware of the leak and took no steps to preclude its publication. The dissent said, no, there is no harm by the email to listserv because the bulk of the harm was suffered by the republication, and because the original email was sent under a confidentiality agreement, it was completely unforeseeable to Bent that this would ever get republished by one of the 670 people that eventually got it. The majority and dissent then went to look at public interest. Remember, this is the core. They all agreed that this raised valid public concerns, and this is kind of importance to the insurance industry because, they all think that disclosure of issues that could affect the fair hearing at a tribunal are very important, and they are. But in the majority's case, they found that the email went beyond just warning that that this was perhaps a practice and that they should get files to ensure that and records to ensure that this doesn't happen. They found that Bent's disclosure of Platnick's name formed a personal attack, and that the same warning could be issued without ever having named Platnick personally. So it went beyond the public interest. The dissent said no, and in saying so, they looked at Bent's motivations and they said that this was purely motivated by significant controversy over the neutrality of experts retained by insurance companies, and repeated that these are concerns about misleading reports or selective reports have been ongoing for years. So they took to that opinion and said, the dissent obviously, that the public interest completely outweighed the harm because, frankly, in their case, the email caused no harm, the original email, where the majority said, no, this destroyed his career. The email and its leak was completely foreseeable that it would cause harm. It outweighed public expression. So we have here the weighting completely different. Now, that gets to, is it working? I suppose it depends on your perspective. Certainly, it's working from the point of view that there's a broad application well beyond defamation actions. And when we look at Section 137.4, you would expect differences in the application because it frankly depends on differences in the factual understanding or the evidence that's submitted and the interpretation of the law applicable to that evidence and the various defenses in the underlying action. Similarly, evidence is required in harm, and so you're going to get different decisions depending on evidence submitted with respect to damages. All of that is normal law, and we understand that. But is it really what is happening with public interest? In fact, I don't think so. I think it really needs some clarity. Is in fact public interest simply subjective? There's no exhaustive definition. The public is definitely a defined group, and it can be any defined group. So how do we do that? Is it a couple of people, or is it just the entire general public? It seems to be somewhere in between. Public interest does not equate to being interesting to the public, but it has a very broad definition, which is by its own by the court's own analysis imprecise. So are we in fact applying fuzzy logic, that is using different values at different times to get different answers depending on the input? Or is that really just the opinion of what's public interest by the court? This is hugely important because we only have the key to anti-SLAPP is public interest. It's understanding what is public interest. And we don't want it to become just a popularity contest. We need to understand how the courts are going to interpret public interest and apply it. Thank you.
Thank you very much, Linda. There are, so there is one comment that asks, when Justice Sabella referred to lingering concerns about defense experts and their neutrality, one of the questions asked whether plaintiffs' experts are neutral. And I won't even let you answer that because we'll leave that. I don't want you to get sued.
Yeah, I mean, it depends on the expert.
Thank you. One question I had is, I see now more and more these online Google reviews. Somebody puts in a furnace and he asks you to review him on Google. Financial advisors, realtors, doctors, they all have these Google reviews. Has that been considered in the context of anti-SLAPP legislation when somebody publishes something that could be defamatory online and whether they can be sued or not?
Yeah, it has in Ontario. I mean, Ontario is not the only jurisdiction, but I'll confine my discussion to Ontario. There's been case Ferreira of a financial advisor, and he was issuing syndicated mortgages, and he got caught up in a publication by a newspaper about the evils of syndicated mortgages, and they named him as being one of the financial advisors who deals with these products. He then brought he then sued them in defamation, and because they were the press, they brought an anti-SLAPP. The court found that this was an expression of public interest, that these products were of interest to the public, but they found that in fact because they had named him essentially sort of along the lines of the majority in Platnick, that he had showed serious evidence of damage, and that his reputational damage outweighed the public interest. So they dismissed the anti-SLAPP motion and allowed the action to proceed. Interestingly, almost the same thing happens with a case of a plumbing company, and they get a posting online of a bad review, and they sue in defamation because it's destroying their business, because this gets picked up, etc. They then they then face the anti-SLAPP motion, and the court in that instance says, no, it's not really public interest, it's just a personal issue. So there's not a lot of, that's the problem with public interest, is that it really does appear to be what's in the judge's mind. And the question here is, do we have to submit evidence? Do we have to show then, now, how do we prove public interest? I mean, how do you convince a court? Because the judge clearly comes at it with their own views, and that gets, and when you read Bent, you can sort of see the way the courts fall. The judge's fall is based upon their personal view. I don't like to say it that way, but it does appear that judicial opinion, private opinion, might be affecting the view of what's public interest.